Ladies and gentlemen, good morning and welcome to the Justice Panel. Justice and the rule of law is what sets democratic states apart from oppressive or problematic forms of governance. It is also a key feature of commercial risk and a benchmark for the attractiveness of a country as an investment destination. The mere existence of a justice system is not an effective guarantee unless it satisfies the requirements of efficiency, timely application, and non-discrimination. The importance of the justice system in improving the attractiveness of Cyprus will be the subject matter of this panel. Our distinguished participants are the Honourable Minister of Justice of the Republic of Cyprus, Ms. Emily Yiolitis. Good morning, Minister. Mr. Christos Giakoumopoulos, Director General of Human Rights and the Rule of Law at the Council of Europe. Mr. Dimitri Papaefstratiou, lawyer and partner at EY UK. And last but not least, joining me here, Mr. George Campanellas, CEO of Invest Cyprus. So I'm going to start off with the first question to our Minister, Ms. Emily Yiolitis. According to the very, good morning, Ms. Yiolitis. According to the very recent EU semester progress report on reforms, and I quote, "The justice system continues to face serious inefficiencies that undermine the enforcement of contracts. Lengthy court proceedings and weak enforcement of judgments harm the business environment and hinder banks from using the available legal tools to reduce non-performing loans. Addressing these inefficiencies would also help to strengthen the payment discipline in the country. Preparations for the justice system reform are advancing, but there are still no tangible results." This is a quote. First of all, how concerned are you with these findings? Are they accurate, and how much do they affect the attractiveness of Cyprus?
Well, first of all, I think that I am very happy to distinguish very close to my heart. That's of justice reform. Due to Cyprus Forum for the our moderator, I cannot disagree with the findings of the EU's progress report. There are indeed serious inefficiencies that need to be addressed. In the right direction is the decision of February 2000 to assign judges specifically to the district court. However, ending the court for the creation of a new special within the district court was submitted about the same time Minister. So that is. Can you hear me clearly?
I think there's a problem with the sound. If we can fix that. We've got some cutouts with the sound. Can you try again, please, Minister?
Well, the Ministry is also building the civil. Is this better?
I'm gonna move to the next question until we try and fix your sound, Minister. Apologies for that. So I'm gonna go to Mr. Giakoumopoulos and ask him. We've got many parallel initiatives at the moment, and one of them is from the Council of Europe. Could you briefly outline the work that the Council of Europe is currently carrying out in relation to the modernization of the civil procedure rules, and what are the long-term results expected to come out of this initiative?
Yes, first of all, thank you for the invitation and to participate in this in Cyprus Forum. The Council of Europe participates in the endeavor through a project which is financed by the European Union, by the Digitalisation reform, and which is enhancing the court system in Cyprus. What we do is to give support to the Supreme Court of Cyprus to complete the drafting of the civil procedure and efficiency of the court. It is part of a wider program, which covers also digitalization of court system, establishment of a court system, and judicial training. I'm afraid that we have exactly the same. I will continue as much as I can. So we have a team. There is a first preparation of rules, which was prepared by a group of international experts headed by Lord Dyson in 2019. Our project is to complete this drafting, assist the Supreme Court in completing the work, but also in particular to enlarge, to reach out and raise awareness of other stakeholders of the justice system in Cyprus, development of a communication strategy, provision of training programs, because our understanding and our experience shows that whenever we produce top-down reforms and which are not shared by all stakeholders, these sometimes do not give the expected results. So this is the part where we are very much involved in, manage the change, introduce performance indicators, and have a tool to assess the results. Of course, the overall objective of the whole process is to have the civil proceedings become faster, simpler, and so that the attractiveness of Cyprus for foreign investors is confirmed.
Thank you, Mr. Giakoumopoulos. I'm going to go back to the minister to see if our technical issue has been resolved. And you were saying, Minister, that the statement of the semester report was accurate. And I'd just like to hear from you how much is that concerning you at the moment, and how much do you think it damages the attractiveness of our country?
Well, the reform of our main priority, and the role of the EU for reform has been instrumental through the publication of markers such as progress reports, the scoreboards, and other. But I think that independent the progress report or everybody in stakeholders independently for the Cyprus justice.
Thank you, Minister. I'm going to go now to Dimitri, and I'd like him to give us the international perspective. Dimitri, as part of the EY Energy Law Team, you've participated in many major projects, including recently one in Cyprus. So what are the best practices? What are the lessons learned from your work internationally that we could draw in Cyprus and attract foreign investment?
Thank you very much, Charalambos, for the kind introduction, and thank you very much to all the other speakers, particularly in light of their bravery in dealing with the particular issues that we're having technically. And I suspect that I'm also not immune to the same problem, so please bear with me. In terms of best practice, what I would say is the following, that all countries in the region, but also globally, are in one way or another in competition to attract foreign direct investment and private capital in particular. Investors, as you well know, and I know that this is also subject matter close to the minister's heart, having practiced law for many years, investors conduct rigorous national due diligence, evaluating the different options they have to deploy capital. And as part of that risk assessment, they look at a number of different factors that might influence their decision. And certainly, the ability to conduct effectively and speedily disputes is critical in informing their decisions. So of course it's very important for any foreign investor to have confidence that disputes that they may arise, or procurement challenges, or other issues that they may face in country are addressed rapidly and efficiently. And so with that in mind, I would commend certainly the Cypriot authorities and the minister and Mr. Giakoumopoulos for all the effort that they have put in trying recently to speed up the efficient administration of justice. Because there is no doubt that it plays a catalytic role in the decision of investors to invest in Cyprus.
Thank you, Dimitri. And we've got the investors' view here through George Campanellas, the CEO of CESA. George, you are in many times the first point of contact from foreign investors. So give us your views. I mean, how much is this an issue for them when they look at Cyprus and assessing a potential investment in Cyprus?
Thank you, Charalambos, and let me thank also the organizers about the invitation to speak to this very interesting panel. It's as the investment promotion agency of the government, Invest Cyprus is obviously at the center of the efforts to promote the country abroad as an investment destination, but also as a destination for international business. It's true also from what we heard that doing business and investing depends on a wide variety of factors, including economic, social, political, but also legal. It's safeguarding the rights is always at the heart of how modern societies work, and it is a prerequisite for locations to compete among them in an effort to become financial or business centers. It's true that our reputation for being a painful, for having a painfully slow justice has a very bad impact in our image and in our efforts. And of course, investors are always looking into destinations that offer them the advantages of safety and security. So overall, how justice is functioning is a very important factor for Cyprus offering, and we have such questions very frequently in our discussions abroad with investors and also with companies that are looking for locations to relocate their operations. It's a common thing to ask.
So thank you, George. Well-voiced concern. Going back to the Minister. Minister, you've recently undertaken the hot seat of the Minister of Justice and the political responsibility to push forward with this reform agenda. Where are we now, and what is your plan to have a long-awaited successful outcome?
So as you may know, bills on justice returns to the Ministry of Justice for their negotiations. What we've done is set up a network working with one representative political party, legal parliamentary committee, as well as the president of the Senate, and together how to find common consensus to bring these back to Parliament. They all concern the construction of the course of appeal, well, or first count with participation of lawyers on the judiciary. So this is where we are on pushing forward the bill which will return to the Ministry.
Thank you, Minister. I'm gonna go to Mr. Giakoumopoulos because obviously this exercise of trying to bring reform about is not something new. It's happening in other countries. So Give us your experience and your thoughts on judicial reforms and how we were able to strengthen the judiciary in different countries.
Well, the Council of Europe, through its monitoring processes, the judgments of the European Court of Human Rights, for instance, or reports of the European Commission for the Efficiency of Justice, most recently also reports of the Group of States Against Corruption, the GRECO, has more or less a rather accurate understanding of the shortcomings in the efficiency of the justice system in our member states. And we can quite clearly identify where these shortcomings are and provide a tailor-made assistance in order to overcome these problems. We do this on the basis of evaluation reports. There have been several evaluation reports concerning both EU member states, non-EU member states of the Council of Europe, but also beyond the geographic area of the Council of Europe, in Central Asia or in South Mediterranean. The problems that we see are essentially linked to the length of the proceedings. Even in the previous panel, there were references to the lengthy proceedings, which may lead to mistrust to justice, ultimately, and inefficiency of the rule of law, but also to the fairness of the system. I would say, in particular, to the trust of the people to the justice system through transparency as regards the independence, as regards the impartiality, appointment of judges, promotions, disciplinary proceedings against judges, and also as regards the implementation, the execution of court judgments. I mean, these are the areas where we see that there may be problems in many of our member states, and this is how we work with them, trying to fix the problem of backlogs, the problem of transparency, communication with the public, making the justice system more transparent and more accessible and more efficient.
I mean, did you have, just as a follow-up question, I mean, give us a success story, if you may call it like that, where you intervened and you've had results in this reform process?
We have had results in working with Croatia, for instance, where we work concerning the establishment of a digitalized, a tool to make the internal domestic law accessible, to avoid incoherences in the adjudication of cases. We have established several remedies, both in criminal and in civil procedures in other countries, in order to make these issues accessible. I would rather say that the Council of Europe's procedures allow a common understanding by many member states and exchange of information and lessons learned, so that these procedures lead to concrete results and to approximation also of the judicial system, so that they make mutual trust also among member states. As I said, we worked with digitalization in many member states, Italy, I would say, but beyond the European Union, Moldova, Georgia, Azerbaijan, quite a lot in Armenia concerning the School of Judges. I mean, there are plenty of, it will be difficult for me to enumerate.
Thank you. So the important thing is that
the projects that we have. You talked about success stories.
Yes.
And this is interesting because I believe that the organization of the judiciary is an endless process. It's very difficult to say that we reached a perfection, but we can fix the dysfunctioning. And then one after the other, we can make the system more performant. But a total success in the organization of the judiciary is an objective that is very difficult to achieve.
Thank you, Mr. Giakoumopoulos. Thank you. And I mean, it's a good pass again for our minister because obviously we have a reform activity. We are in some point during this activity, but what can we do now to have some tangible improvement until this reform bears fruit? I think we may have lost Minister Yiolitis. I'm going to turn to Dimitri then. Dimitri, you have worked in many places around the world, and you've handled clients. So, looking at it from the clients and the investors' perspective, how important is it when they are assessing an investment into the country? How big a risk management issue is it for them?
So it certainly is a key risk issue, and particularly in a world of investments within an EU context, where you have investment returns being constrained as a result. This is not an emerging market. This is very much center of the EU, a very developed market, and so on. And so equity returns are by necessity constrained. If you look at the risk weighting that each investor places, not only on the ability to resolve disputes and conduct their affairs in a sensible way, but also on their ability to raise domestic finance, if necessary, their ability to conduct their business in country, then if within that world of constrained returns, you see that there are significant outliers in terms of additional risk factors, such as, for example, excessive court delays, the risk of malicious or difficult prosecution. And we've seen that in cases, for example, in certain countries in the Balkans, where you might have objections to projects being launched essentially as a way of delaying them and stalling them. Investors will take that sort of risk very much into account. And they will look at the different options that they have and essentially adjust their investment accordingly. And this is in particular if you look not only at the type of investor who is long-term patient capital, but certainly investors who have constrained horizons in terms of the investment that they're able to effect in a particular country. So if you look at most private equity funds, for example, or other types of similar investors, they will often have 5-year horizons, for example. If that horizon, that investment tail, is taken up by inefficiencies in court systems, for example, because there is an objection to a local investment being made, that will absolutely feature heavily in their decision to invest in a country.
And also
or
in
indeed
cost.
to retain their investment.
Yes. And do you think there's a cost integrated into that risk? So, for instance, higher pricing sometimes?
Not sometimes, I would say it's absolutely the case. The greater the perception of risk, whether it's credit risk, commercial risk, or legal risk, the greater the risk weighting on capital, which will mean ultimately the greater the cost that a consumer has to pay in order to compensate that capital for the risk profile it's attracting.
Thank you.
So these are not matters that are abstract.
Thank you, Dimitri. And I'm going to turn to George. So, George, what do you think can be done realistically where we are now? We've heard in very sort of blunt words the current status. What can be done in your view?
As the investment authority of the government, we have been always trying to promote the shape and reshaping of the FDI framework. So obviously, this is a subject that has been put on the table the last few years. And we've seen a lot of rankings, like the Doing Business report of World Bank, showing exactly that changes need to be made. We are glad to hear and to see that the process started. We understand that it's a process that it will take some time to be implemented, but we need to act fast with what we can as a country and as a state by obviously staffing better the courts, compacting the backlog that has been there to limit the time of the cases that are being brought to the courts, and also perhaps find ways to give more opportunities to our judges for more specialized training. Nevertheless, we have a number of structural changes that need to take place in Cyprus, and this is obviously on the very top. We as Invest Cyprus, we have been always preparing bills or drafting legislation and giving it to the ministries to push it forward, like what we did in the past with the investment funds legislation, with the filming, now with with a number of suggestions in regards to immigration of third country nationals that are going to be presented in the Ministerial Council. All in all, this is a horizontal issue. The issue of justice is a horizontal issue that covers all the sectors, and most importantly, has direct impact on our image, the country image, as a destination. We hope that the minister's plans will move forward.
In 1 minute, though, I mean, from the business side, do we need to go to court always? I mean, what can you do to change the culture of our businessmen so that not everything ends up in court?
That's true. It's in the culture of our ecosystem to always go to the next level to find justice. And obviously, some of the cases that we're hearing is that there are firms that instead of paying what they need to pay, they prefer to take the easy route of the court to delay the whole process. And I guess you know better from your profession that this is also
delay tactics.
Yes, a plan B in many times.
Okay, which is a good pass actually, because the next question is for Mr. Giakoumopoulos. You know, when you try to put to set a limit to the access of people to courts, everyone starts saying, but the human rights. So I want to ask Mr. Giakoumopoulos, are these really incompatible notions? How do we achieve protection of fundamental human rights and enforceability and efficiency of commercial rights?
Let me first jump on your previous question, which I found extremely interesting. Do business need to go to courts all the time? And I think that they certainly do not need to go to courts all the time, but when they go, they need to have a court which is performing well, that has proceedings which are speedy, that are fair, and that the decisions are implemented. And this is probably the reason why also the international financial institutions, the IMF, the World Bank, even the European Bank of Reconstruction and Development, make a very clear link between the performance of the judicial system and the investments and the financial support. I would even say that this week's European Union's Rule of Law report, which has been issued Wednesday last week, there is a lot of discussion in the European Union about the link between rule of law, performance, and the financial support that may be given by the European Commission. I mean, this is still under discussion, but there is a discussion about the conditionality in this respect.
We have the minister with us. I'm being informed. I think I'm getting my wife's profession today as a newscaster with these technical issues. Hope I'm doing well, and sorry for that. So Minister, if we have you with us, we've heard about the need not to go to court all the time, and there is a lot of multi-layered reform. Yeah. So I was asking what we can do to have a quick, successful, tangible result now, and whether ADR is an option, how we can change our commercial culture. So your comment, your view on how we can have something apart from the legislative reform.
I apologize for the interruption. I hope you can hear me better now.
That's great now, yeah.
Wonderful. So the current justice reform bills, which we are working on, as I said before, concern structural reforms, the restructuring of the Supreme Court, the creation of the Court of Appeal, and the expanded Judiciary Council. However, what we need for justice to move forward are also those procedural reforms that are going to unclog the system. The Dyson Committee has made some recommendations for the complete overhaul of the civil procedure rules, and they are currently being translated since 2019. It's a huge project into Greek. My personal opinion is that some points of these civil procedure rules, because by the time this whole project is completed, they might some part of the e-justice process will also be completed. So it's very likely that they might, to a certain extent, be outdated. I would say that we prioritize certain points, such as the small claims procedure, whereby for specific categories of small claims below a certain threshold, these claims can be filed electronically and decided by a judge within a set time frame. There could also be a limitation on the right of appeal for such small cases. Just as a side comment, Mr. Prountzos, I have asked the court registrar for statistics on appeal cases, so as to build a case for a limited leave for appeal. And the statistics that I got were rather worrying, because first of all, the statistics which were given to me were from 2013, because thereafter appeals are still being pending. So since 2013, appeals which were submitted in 2013 before are still pending today in 2020. So in 2013, which is the last date that we have statistics for, of 359 appeals lodged and 278 heard, because some were settled before they were heard, only 12% were overturned at first instance, overturned the first instance decision, and the appeal time for the reversal was a little over 6 years. So as you can see, the numbers speak for themselves. I would say that even small changes, such as disallowing multiple adjournments of court cases, would go a long way in unclogging our justice system. In Paphos, we have the backlog of delayed cases, which has started now on a trial basis. And just this month, the judges have cleared 148 cases. And I think this is due a large extent to the fact that they disallowed adjournments. You will also be aware that the new reform bills, which I am currently pushing towards with the ad hoc committee, contain provisions for the creation of a commercial and an admiralty court. Now, it's very likely that the vast majority of the cases that this court will hear, which has jurisdiction for cases of over 2 million, will concern not differences between Cyprus nationals, but international cases of investors who have chosen to set up their companies in Cyprus, or to provide security for a loan by pledging Cyprus shares, or they have a difference in their shareholder agreement. Now, Cyprus has achieved recognition, as the panelists have noted, through the use of regulatory tax and other competitive advantages as a world-renowned services center. What we haven't been able to do, really, is be as proactive in advancing our jurisdiction as a center to settle differences. And the big reason for this, of course, has been the big delays in the court system. But we can attract international investors to Cyprus to settle their differences by setting up this specialized court and by allowing innovation. And one of my suggestions, which I hope that the stakeholders will support, will be to allow the English language in commercial disputes before this commercial court, which will be a special court, where both parties to the proceedings are non-Cypriots and they both agree to use English for the proceedings. My personal opinion is that we must not delay in making those procedural changes, be they small or big, which will unclog the system.
Thank you very much, and very, very concise response, Minister, and it's a perfect, actually, pass for the question I wanted to ask Dimitri. So, Dimitri, you live in London, you practice in London. Tell us, how has London done it? I mean, what is the key that made London not only a commercial center and a financial center, but also a choice of venue for disputes?
So thank you very much for that, Charalambos. I think I would pick up on a couple of the points that the minister made as well in this respect. So I would say, firstly, that English courts are very effective because they are highly specialized. So the division of different courts into different areas of specialization, particularly with commercial disputes, is fundamental in the success of the English system. What I would also say is that investment in the administration of justice is a very important part of achieving a successful outcome. And so, for example, I note that in this context, that comparatively, if you look certainly at EU statistics and Eurostat statistics, that Cyprus on the whole has quite a low level of investment per capita in the effective administration of its judicial system. And certainly what I would point in contradistinction is that actually in the UK, certainly there is quite a significant investment, although I'm sure that UK judges would tell you that it's not enough, but certainly, and perhaps it's never enough, but certainly there is a significant level of investment in the administration of justice and disputes in the UK. So investment as well as specialization is key. And then finally, what I would say is that within the UK, and certainly as regards English law, there are efficiencies to be gained by essentially converting the speedy administration of disputes and efficacy of justice into an export tool. And I suspect that when the minister was talking earlier about promoting Cyprus as a center of resolution of disputes for investors who have also set up their businesses in Cyprus or domicile themselves in Cyprus, the ability to speedily resolve disputes and administer justice efficiently is also an export tool and tool for export promotion. So I would commend that approach very strongly.
One last question for our minister. Minister, I picked up on one point that you've made, that by the time we finish with this reform process, part of it might be outdated. And to me, this is probably the most important statement made, because it requires courage to intervene, to actually change something that was supposed to change the old status quo and make it appropriate for today and tomorrow. So my final question to you is, how could we intervene in a reform process that has been going on for 8 years now to make it a post-COVID, timely and effective process?
Well, first, let me say that my comment is to the delay and as to the outdatedness of the provisions, if and when they are enacted, refers to the civil procedure rules.
Correct, yes.
Because they are being discussed for a very long time, they're being translated for a very long time. I think that by the time that they are enacted, some of them will already need adjustments. So that's why my suggestion is now we are modernizing the structural justice system by the creation of the new courts of appeal and by the restructuring of the current situation as it is now with the Cyprus courts. The creation of the specialized courts, the reorganization of the Supreme Court. These are going to be modern, new provisions, which I hope will be able to help litigants to a faster and more effective justice system. I think that will be a very effective way, and we are really pushing for this. And I feel in the few meetings that I've already had with all the stakeholders that everybody is on board for pushing through for this as fast as possible. The outdated provisions really concern negotiations which happened many years ago, which we now have to see again before bringing them to Parliament, just because e-justice is catching up with us. So I think that there will be a coordinated effort to promote some parts of the negotiations that have preceded in the years before, but a lot of the reforms that are going to be pushed through now will concern the new structural reforms and some selected measures which are going to drastically and quickly unclog the system so that we can deliver faster and more efficient justice.
Thank you very much, Minister Yiolitis, George, Mr. Giakoumopoulos, and Dimitri. Thank you very much for your contributions. Hopefully, by next year, we might have some tangible results to present. Thank you very much.